What's up, viewers, subscribers, and agents alike? This your boy Enlightened Luciferian Prince coming at you once again. And I want to say that everyone that I emailed within the previous 24 to 48 hours, please check your email. If indeed you don't, I will not respond again. Based upon your response, you get a response from me. So everyone that said that they emailed me previously, I emailed you. And if you don't email me, don't expect one back. It's just that simple. I keep it moving. Now, the topic of discussion today is going to be child support and a doctrine known as Parens Patriae. Now, Parens Patriae is a doctrine that is utilized by the courts to basically establish the incompetence and the mismanagement that has been often associated with people who actually have children. Now that we know that throughout this process that most of the time the contracts are established between the birth certificate and the so-called negotiable absolutes, which are the social security numbers that are attached to contracts, the obligations that are often tied to parents that have children. Now we can get a little bit more in depth with the approach to what the child support issue really is. Now, this is not a video that I'm placing on YouTube to say, shirk the responsibility that most people have in regards to kids. It's not. This video is to go in depth with the approach as to what the legal notion is behind it, so you can go about the process in the correct way. Now, I'm going to start by reading something which is from, Wikipedia, which basically, in and all of itself, was actually written by a law professional and definitively goes into the definition of what Parens Patriae is. Parens Patriae is Latin for parent of the nation, literally parent of the fatherland. In law, it refers to the public policy power of the state to intervene against an abusive or negligent parent, legal guardian, or informal caretaker, and to act as the parent of any child or individual who is in need of protection. For example, some children, incapacitated individuals, and disabled individuals lack parents who are willing or who are able and willing to render adequate care, thus requiring state intervention. In U.S. litigation, Parens Patriae can be invoked by the state to create its standing to sue. The state declares itself to be suing on behalf of its people, which we know by now in the corporate format it's not. For example, the Hart-Scott-Rodino Antitrust Improvement Act of 1976. This is 15 United States Code 15, Section C. Through Section 4C of the Clayton Act permits state attorney generals to bring Parens Patriae suits on behalf of those injured by a violation of the Sherman Antitrust Act. Discussion. Parens Patriae relates to a notion initially invoked by the King's Bench in the 16th century in the case of non-compos mentis adults, which I said before in the previous video means not mentally competent. The notion dates from at least 1608, as recorded in Coke's report of Calvin's case, wherein it is said that moral law, honora patrium, doubtless doth extend him that is pater patriae. In modern day vernacular, it means basically, doubtless does it extend him that is the father of the country. Simple. The Parens Patriae doctrine was gradually applied to children throughout the 17th and 18th centuries, and has since evolved from one granting absolute rights to the sovereign to one more associated with rights and obligations of the state and courts towards children and incapacitated adults. Now, whenever we hear this word incapacitated, we often associate it with not really being mentally competent enough to be able to deal with daily affairs and occurrences. But this really means, in some senses, it could really mean economically incapacitated. It could mean occupationally incapacitated. It could mean so many things. It could mean socially incapacitated, which also means that you're basically in jail, so you really can't take care of your child. Whatever the case may be, incapacitation has to deal with the inability to take care of a responsibility. In most jurisdictions, this appears in the principle that makes the protection of the best interests of any child the first and single most important concern of the courts. Because again, this was the byproduct of the union between two live biological human beings who actually intermerged and created a product of their union. And that's the reason why the court system takes so much interest in it because they can apply a new tracking number to it. And since it's not mentally competent enough, then the state would deem itself responsible enough to take care of the affairs of the child's life. That's why every time something happens between parents and children, whatever the case may be, the first person to intervene is the Department of Children's Services. They may call it something else where you live, but it's nonetheless the same. For example, in any proceedings affecting the validity of a marriage, the children will not be parties in their own right. Again, non compos mentis. Nor will they be parties to any agreement that the spouses may make. In these proceedings, the courts will often be invited to accept and enforce any agreement between the husband and wife regarding paternal responsibility to their children. This will usually be done so as long as the agreement is seen to be in the best interest and welfare of the children. Courts are not obliged to invoke the Parens Patriae doctrine in cases involving children, and not all courts particularly. Newer courts, such as the Family Court of Australia, have specific Parens Patriae jurisdiction because, again, it comes from the Romanic, Germanic ideology, Anglo-Saxon law. And they apply it in Australia because, again, that's a so-called Commonwealth territory, which comes from the Bar Association, which holds their law and bar in rem in regards to the Roman Curia. Long story short, we'll get there sometime later. In the United States, some proponents of homeschooling have asserted that Parens Patriae doctrine is constrained by a so-called paternal liberty doctrine. In some situations, the parties may have submitted their dispute to formal arbitration proceedings. Such proceedings, whether judicial or quasi-judicial, somewhat judicial, cannot displace the supervisory power of the court in the exercise of its Parens Patriae function to the child. To the extent that such an award conflicts with the best interests of the child, the courts will treat it as a void in respect to the child, even though it might not be binding on the parents, or even though it may be binding on the parents. The test of the best interests of the child can always be the basis of a challenge by a parent, grandparent, an interested relative, or the child acting through a friend, which in most cases often happens today. Thus, for example, the spouses might already have been through a religious form of divorce known as the get before the Beth Din, the Jewish rabbinical court, which included provision for children. Even though there might appear to be a grant of custody in absolute terms by the court, public policy always requires that it can be renewed by a secular court. And if the state court is of the view that it's not in the best interest of the child, it will be set aside. See Stanley G. versus Eileen G. New York Law Journal, 10-13-94, page 22, column 6, supplement, Connecticut, New York. Within the EU, the European Union, the right of the child to be heard in any proceedings is a fundamental right provided in Article 24, Charter of Fundamental Rights of the European Union. The views of the child should be considered on matters which concern them in accordance with their age and maturity. It also provides that the child's best interest shall be the primary consideration in all actions relating to children, whether taken by public authorities or private institutions. The same principles apply to individuals whose mental capacity is impaired and who are being abused by carers or other individuals, whether family members or otherwise. Since these individuals cannot protect themselves, the courts have an inherent jurisdiction to appoint a guardian ad litem for particular proceedings. In English law, long-term care is arranged through the court of protection. Now let's go over that definition, guardian ad litem. A legal guardian is a person who has the legal authority to care for the person and the personal and property interests of another person called a ward. Guardians are typically used in 4 situations: guardianship for an incapacitated senior, guardianship for a minor, and guardianship for developmentally disabled people. Now, we have to also understand that in regards to this law, we have to realize that pertaining to the law, person does not mean live, natural person. It's a person. It's a natural person. So we have to be aware that when we view these things, we have to view these in the light that whenever any child support proceedings take place against individuals, such as individuals, partnerships, trusts, or corporations. So unless you have proper standing, unless you have actual proper status in regards to courts, whenever you go to court, you're going to lose at every chance because you haven't practiced what's known as mental competence. Mentally competent legal adults actually provide the remedy to their own situation. And this is one of the reasons why I stress the redemption process. The redemption process means that you're now displaying competence. You are now mentally aware that your affairs are being handled according to maturity and not the guardianship or the wardship that the state wishes to superimpose upon you in regards to your proceedings. If you indeed don't get that, please play this video again. Or if indeed you don't get that, please email me. Subject line, child support. Now, the reason I stress this is because, again, I get a lot of emails with a lot of verbiage in it, like this long, about something that I don't wish to hear about because it takes too much energy and too much time to review that one circumstance. So, if indeed you have not embarked upon the path of becoming a secure party creditor, if indeed you have not embarked upon the path of actually taking the legal responsibility from the state and putting it upon yourself, which is what you should rightfully do, then you must email me in regards to that. I'm not going to put it out there in the public venue. This is private remedy. This is not public remedy. This is just public knowledge of a private remedy. But this is not a public remedy. Now, lastly, I say, I think years ago when I did a child support video, I think somebody left in the comment section. They said that I was a deadbeat dad. Let's set it for the record straight, people. I don't have children at all. You know, there's no ifs, ands, and maybes. There's no children that look like me or share my genetic complex anywhere on the face of this earth. So I'm not shirking any responsibility to take care of my children. When that time does happen, in that time, in its own due time, then yes, it will be taken care of appropriately. But that's not the time right now, so I don't have to worry about that. You know, but long story short, I'm letting people know in the public video that this is not about trying to escape the responsibility in regards to your personal life. You know what you do best. You know what you're supposed to do. And any man that's worth his weight in salt, you know, takes care of his own. But I don't think that the state has to superimpose its abilities to otherwise disadvantage you or disenfranchise you in regards to your own personal life. So you have to take responsibility of your personal life in order to have success. So, long story short, you're operating under a system of Anglo-Saxon Germanic law. And you have to realize that this comes from a disheveled people, and it comes from a system of two boys who swear that they were raised by a wolf. And now you realize where the serious problems come from. Stay tuned for the next video. The next video I will do and upload, it's ASAP, will be the variance between the 1040 and the 1041 and 1040 NR. We'll get there. Trust me. Stay tuned. And agents, you know what it is. Peace. Like I said before, if you need the remedy, contact me via email. And please, don't send me a journal. Take care. Stay tuned.